Es para mí un placer compartir la mesa hoy día con dos destacadas y destacados juristas, académicos, pero también gente muy vinculada a las transformaciones necesarias del derecho de las familias, de los derechos de la niñez y del derecho constitucional en sus jurisdicciones y en sus regiones. La sesión del día de hoy la denominamos el derecho a la vida familiar en movimiento, porque esperamos que las presentaciones de Marisa y Conor, a quienes presentaré luego, sean ejemplos de esto, cómo estamos frente a un campo del derecho en constante transformación, y eso implica desafíos profundos a la comprensión del derecho constitucional y los derechos fundamentales en el ámbito privado o civil. Las presentaciones será así. Primero hará su presentación la profesora Marisa Herrera y luego el profesor Conor O'Mahony, y los voy a presentar al momento en que cada uno haga su presentación. La doctora Marisa Herrera es abogada y doctora en Derecho por la Universidad de Buenos Aires, en Argentina, donde es docente ya hace algunos años. Ella también es investigadora independiente del Consejo Nacional de Investigación Científica y Técnica de Argentina, el CONICET, y ha sido una persona que ha participado no solo en una enorme cantidad de proyectos académicos, es una inagotable intelectual, para fortuna nuestra, pero también es una persona que ha participado pero muy directamente en distintas transformaciones, por ejemplo en Argentina, con lo que se denomina, que ya cada día es menos nuevo, el nuevo Código Civil y Comercial del año 2015-2016, que es un referente para quienes trabajamos en el derecho familiar constitucionalizado, y otros procesos de formación para juezas.
Lawyers in Latin America. She's a friend and collaborator for the Center for Constitutional Studies. Professor Herrera, she's going to be presenting now, which is called Progressive Autonomy, Socio-affectiveness, and Right to Family Life. We are going to have two 25-minute presentations, and then we're going to leave 30 minutes for remarks and questions and to talk to them. Marisa, the floor is yours. Thank you. Hello, everyone. Thank you very much. It's a pleasure to be here, and I want to thank the Center for Constitutional Studies and the network that has created the center, especially Nicolás, for creating these spaces, and of course, Mexico's Federal Supreme Court. Well, my topic today concerns progressive autonomy, social affectivity, and right to a family life. Why in law we speak about right to a family in these broad terms? And I'm going to be showing my arguments. What's social affectivity and what is progressive autonomy? And as Nicolás said, I really like the name he chose for this panel, because it concerns the right to family life on the move. And this is a motion, a complex motion. When you are changing, you are never in the same place, and these changes are transformational changes that send access on a different perspective with respect to a family's rights. I want to start with this phrase that is going to be behind my presentation, and I'm going to remember Mario Benedetti when he said, when we believed we had all of the answers, all of the questions changed. And I am convinced that human rights have changed to the questions that we were making ourselves some time ago in the family field. And this is the perspective of this talk. First of all, we have as starting an arrival point this conventionalization. One cannot exist without the other because both are part of the same. International and regional. That's why in Latin America we are so concerned about the progress we made at the Inter-American Convention of Human Rights, not just from legal precedent. And in this context, we have two important focuses that have been key in this critical review of a right to family life in contemporary times. One And then here we have the childhood and gender focus. Gender in plural, genders. Genders today are pivotal so we can understand the right to a family life from a different and more complex and more intersectoral perspective. And what does it mean, gender focus? To speak about actual equality, we have to rethink gender stereotypes. The stereotypes of good mothers, bad mothers, everything that is behind parental responsibility and the right to a family life. And that's why I like this a lot. And I know that we have in Mexico City this exposition of Mafalda, this Argentinian character. She always being asking in critique, what would you like to be if you were living? So the role of mothers, why we women are the only ones, or must be the only responsible ones for taking care of our children. So that's why I'm speaking about co-responsibility, co-parenthood. These are key elements so we can think about traditional families and a more broader law. And then she says, what does a professional woman today who is successful and responsibilities feel? And she is a mother of three children, and she says, I feel guilty. So that's the base of guilt as well. This is something that we should start to consider because most of violence cases are gender in nature. So now the problems with maintenance by a man with regards to men to women are different. So this goes deeper in family relationships and making this visible, in a deconstructive and a constructive way is something we have to do. And this concerns progressive autonomy and the democratization of family relations. In here we have Mafalda saying, "Good morning. Who is where is the boss of the house?" As we say in Spanish. There is no boss here. So where is the place? We have to have the children at the central place of decision making within families. So, right to a family life is today right to a plural family life, which also concerns the different ways in which we can live families. And the right to family life concerns a plural nature of the different forms of family, and also we have assisted reproduction processes, and this has allowed for these forms to be broadened. Now, in regional terms, we cannot bring things to the table from the sentences by the Inter-American Court of Human Rights. And it is speaking for the first time of the topic of sexual orientation as a spectral category. And then in an adoption case, we also have here monoparental families, and there is nothing that indicates that the monoparental families can't provide love, care, and maintenance to children. So there is no always mother or father in figure in families, and this means reconfiguring the right to family. What does this mean? This obliges us to give a different content to the right to family life. First of all, access and respect for the different types of family, and this idea of respect and non-inherence by the state, and being able to respect the different forms of families. But also we are going to have this different element, which is the possibility to enjoy science, because the reproduction techniques have allowed us to have different family forms to such an extent that in some countries like Argentina, assisted reproduction skills are another possibility for the establishment of relationships between parents and children. And this idea of interdependence of human rights and how we have a game in family life that is not going to be there alone, well, this is going to concern the human rights that we must take into account, right, to the development of your own personality as the acknowledgement of right within the family. And I mean, the right to have a personality within a family, and as a pivotal right, this concerns, the link to family life. A child who has been for years in home, once they are separated from the family, the child is going to start forging their identity and their links within the family. Therefore, identity and the dynamic that builds it is something that we must take into account when we are speaking about family life. And this means to rethink about identity, as a Peruvian Frado Cesarego was saying. There is a static and a dynamic stage, and we're going to be concerned in the right to family life at the dynamic stage. Everything that one is going to be building from affection relationships, even outside the concept of family, and because also community is a pivotal element here. That's why we're speaking about state obligations in a passive and active form, what concerns to do and not do. And we have the three powers of the state: legislative, judiciary, and the administrative. That's the executive one. The three of them have very clear responsibilities with regards to the respect of family life, both in terms of doing and not doing. And in this respect, we have some constitutional concepts which are our guidelines. So that's why we have this international network. So we have in the constitution a conventionalized idea, and we can see in Latin America three types of constitution. We have a broad constitutions, and their broadness today is being deepened, and not just broad, general, as it happens in Argentina when they speak about 14 BD, comprehensive protection of family, but they do not define what family is. But also today we're going to have a broader stance, a more precise stance, as the one that is being debated in Chile today, where not just they are acknowledging the right to family life, but they also acknowledge the perspective of affection, and they say the state is going to acknowledge and protect families in their different forms, expressions, and um, ways of life without restricting them to only blood or parent and children relationships. So, the constitutional for the constitutional law to have this definition of family, you know, makes me to start thinking about the right to plural life, family life. Now, the text that is being debated right now, and here we speak about children's rights and everything that concerns their development needs. The state has to make sure that they aren't separate from their families as a temporary and last resource. And what does it mean for the reinforcement of family and public policies in a right to a family life matters, but this is also going to link work to family life. The state is going to elaborate public policies that allow to have the community, family, and professional lives. So this is a broader right to a family life from the Constitution when they consider the link that is with the right to work, the right to housing. Housing is the habitat where right to family life is going to be developing as well, and family reunification is another important element. And a constitution to for a constitution to have the possibility to have a broader vision of a family law is going to give you a broader outlook. What else? Now, when we're speaking about the more contemporary regional reality in Cuba, we're going to have the referendum for families, and it's called the Code for Families. And the Article 4, they speak about the rights to be respected, one of which is a right to family life. And that's the second one that is going to be listed in the text. And it says, well, all of this constitutional conventional framework takes me where? Where am I headed? What's our direction? I'm going to give you a working hypothesis. I am convinced that today the notions that are challenge and make tensions with regards to family life are two: the concept of socio-affectivity and that of progressive autonomy. Today, the right to family life, in its more contemporary trend, is crossed openly by these two big notions. And where we are going to have we're going to have the impact of this in the filiation aspect and that of parental responsibility. And what about this? Well, first we're going to go to parental responsibility, which is the concept of responsibility in itself. And we have the Article 5 clearly by the Convention of Children's Rights, and it speaks about responsibility as linked to parents and children or filiation. And this means reinforcing co-parenthood concept, not just as a central mother and a peripheral father. We are well, they are both critical to their children, and also the concepts of gender in some families. In some families, we don't have a mother, we have either two fathers or two mothers, and this concerns what the limit for their parental responsibility is. It's not the same as having children of 5, 7, 13, 17. All of them are minors, but it is going to have an impact on the content of that linkage that they have with their own parents. So that's why the content of family life and the right to family life concerns and entails a very broader spectrum from the more traditional aspect of the right to the family of origin, but with these diversities, and also we have the right to family life with affection reference, with broadened family, right to family with the foster family, and the link that children are going to be forging in these homes as well. Programs of of adolescents for whom adoption is no longer an option because they don't want to be adopted anymore. How the state is going to accompany them to help them in becoming autonomous. How we're going to create community effective relationships and the right to adoptive family life. See how the right to family life is going to be enriched even from the fields, subjective fields, and depending on with whom they're going to be. And this entails the preservation of family relations, but to which point, when we have violent families, abusive families, what's the topic here? And then we have another topic, which is poverty. Poverty can't never be a reason to separate a girl or a boy from their family of origin. So that's why we have the public policies of for the reinforcement of family. And in here we have to have the collaboration for the right to family life from the social, cultural, and economic rights. And now we have the affiliation field here. And I'm going to start to move to the second part of my presentation. And today we not only have the biological family and the adoptive family, which are where the traditionally the largest groups of affiliation, but also assisted reproduction techniques and beyond. And then we have practices that aren't regulated and that concern what are home practices. You know that lesbians do not have infertility problems, medical infertility problems. It's a problem of sexual orientation. Therefore, a friend, informally, a male friend is going to provide the semen, and they're going to be self-inseminated, and they're going to become pregnant. How's the game of affiliation? Who are the mothers and fathers in these cases? So those are the issues that we have to cover today. And the third one, which is more contemporary, is socio-affectivity as an autonomous cause for affiliation. And I'm going to see this at the end of my presentation. All of this concerns the need to differentiate when we have a source affiliation, I mean social affectivity, and when the social and affective link is going to beat, so to speak, the biological link. That what does it mean of girls and boys that were acknowledged by a man, but after 10 years, 12 years, 15 years, believing they were their father, they realized he was not, and then we have the biological father that comes into the scene. Is biology everything? Is DNA everything that are going to mark affiliation? So that's why they're going to say, no, no, no. My father is the one who always treated me as a father, with whom I have a huge affective relationship. I have the DNA of this mister. So is DNA everything? So these are two different types to consider social affectivity. One, we're going to have the creation of affiliation, and then when we're going to be solving filial problems, as the cases of the reunification affiliation processes as complaints. In Colombia, we have had these cases not so long ago, and we start to differentiate these two trends. But besides, we have within everything that concerns home practices that I'm going to be to which I'm going to be going back later on. We have home self-insemination. Those women within lesbian couples that have relationships just to become pregnant, but that man will not become responsible for this child. And in here we also have more complex situations that we have even had conditions of oral sexual activity, which is the case of Mexico. We have a very famous case where, and in here we have the case of someone who works, in the judiciary of a specific federal state. They have, a relationship with a colleague. They were together for 1 year, and during the last time they met, they practice sexual, oral sexual activities. She keeps the semen in her mouth, and then she's going to self-inseminate herself. So, how rules are going to be here? One would say, if I use biological affiliation, of course, the DNA is going to tell us that the mister is the father. But if we do not have the procreational willingness, and if that man did not want to become father, and he became a father because of deceit, because he was deceived. So the question here is, what's the impact of the higher interest of the child? How can we claim for affiliation here when we had such a deception? Because we also have to start to consider these governing principles, and in this case, what the federal state said was, okay, DNA established, he is the father's, and he is the father then. If that it was the only time when they practice oral sexual activities, so we have to start making more complex questions. So that means being a mother or a father at which cost, even at the cost of deceiving. And I'm going to start concluding. Right now we have more complex issues, which is, binarism, filial binarism. That means, in the filial link, and also between adults, because we can only have one couple or one marriage or one union between two people and no more, what is known today as holy love. So, what's the limit? What's the idea of love, of autonomy? We can speak about, I can form any type of family, or there is always, or should it always be binary in nature? And what happens with the link with the children? And here we're going to deepen on the second issue. We know that there was a highly debated case on holy love here, and in the Mexican federal state of Puebla, we had a sentence, and also in Colombia, the sentence that acknowledges holy love. And see, because of the lack of law, I'm going to go to justice, and then in justice, I'm going to get the acknowledged with that plural perspective. And in Argentina, we do not have a poly love, but we have had cases of a poly love between um, adults with respect to children. And in Argentina, we have 22 sentences or 22 cases where the acknowledgement of a triple filiation have been have a reason. So we have biological, we have adoption, reproduction techniques, home practice. So all of the types have been faced to the possibility of a triple filiation here. And the question that one can make oneself is, what do we do faced to this reality? Social activity has a strong weight here. And the project of Code of Families of of Cuba, which is the more modern in the region, which is to be voted in no time, is going to conceptualize the filiation in this way. Filiation can take place by natural procreation, by the legal act of adoption, by the use of any reproduction technique, and by the links that are built from social affectivity, which is acknowledged legally. It includes procuration and parenthood, as well as social and affective links. And I'm going to close with this case that took place in Argentina this year, which is the first case, which is double and double novelty because it has three affiliations, but it's the first case where we have a social affectivity, and it's going to be the source of these triple affiliation, and the acknowledgement to a different uh, family life. So, a woman has a daughter with a man, Then they separate, and she gets into a couple with another man. 15 years later on, after having such a strong, affective, link with the girl, because he took care of her, and given, she decided to go live with him, and he's like, I'm here because I want to start affiliation act, not to displace any of the parents, because they were, the girl was undergoing violence because of her parents, because of my social and affective link that I have had with her since she was 7 months old. So what's interesting from this case, not just the fact that social affectivity becomes the source of affiliation, but the adolescent, appears herself saying, he is my father for me as well. He raised me since I was 7 months old. I'm an adolescent. I have been living for her for years. How will he not be my father? And I'm asking, I'm asking also to have his surname, and that's why the magistrate said that those are the violated rights, which are the rights that are being violated because our legislations do not accept this movement to the right of a family life. But this is accepted when we have the conventional perspective, and then we're going to say like the most beneficial for them from the optics of protection of her right is to acknowledge the triple affiliation. What's interesting here? Well, for the last part of the sentence, the judge is going to devote one single paragraph to her. What M wants is for this man to be included in his birth certificate as your father, without disacknowledging your biological parents. Something you have very clear, because for over 15 years he is the one who has played the role of father, and he has always looked for the best for you. He has always been there with you throughout your life, and has proven you he loves you as his daughter. This paragraph that goes for her is the humanization of family processes that also come hand in hand with procedural law. Definitely, someone coming from the cybernetic world that concerns emotion, as Nico was saying, for the title of these talks, the 21st, ABC is not for those who cannot read, but for those who cannot learn, de-learn, and relearn. And that relearn aspect is anchored in a perspective of human rights, what it means, what a more inclusive society means, a more pro society, more diverse society means, and for that it's necessary to invite us all to de-learn and relearn for the right to really reach everyone. Thank you very much.
Thank you, Marisa, for this tour de force, for all of these basic concepts to somehow. I would like to stay with that final case that you shared, how all of these discussions that we have on the role of the Constitution and the different principles of the Constitution and the interpretation of fundamental rights, and all of this load that we have, this burden that we have, constitutionally speaking, how it is so specific for social processes about the construction of the identity of people. So we were also discussing this during this morning with Connor and the role of the judges. And there's something here that we are investigating. The Supreme Court, the constitutional courts are investigating on this, but it's the judge locally, the local judge, that will be facing these real cases with the transformations of family life, all of this movement of the family life. And if we don't get to those judges, then probably we'll have really good sentences and books and publications, but not the real decisions that signify the real interpretation of the Constitution, the criteria and humanity and openness, as you said by the end of the presentation. Thank you. Hopefully, we can discuss a little bit more about that in a minute. Now, I would like to introduce Conor O'Mahony. He is a professor of Cork University, College of Cork, in in the law school, and he's also a specialist in child rights. He was a special rapporteur appointed by the government of Ireland for the protection of children's rights. He was in charge of this for 4 years, and he has been a scholar that he has been involved globally and working specifically in the relationships that exist between the constitutional law, the children's rights, and the right to family. So his contribution has been really huge in Ireland and in the rest of Europe and in other countries where he has supported some constitutional reforms to actually do this intersection between these new reforms and constitutions. So it is a pleasure to have you with us. Thank you for making that long trip. So the floor is yours, Connor. Muchas gracias, Nicolás. Gracias a todos en el centro por la invitación y a todos ustedes por estar aquí esta tarde escuchándome. Perdón porque mi español no es nada bueno para poder hablarles en su idioma, así es que espero que puedan seguir lo que les estoy diciendo con claridad a través de la traducción. Voy a comenzar.
A little bit on the right to family life and why it is that we all think it's so important. And to begin with the statement of, what is more important than family? And that is something which you will hear said in almost any country in the world. It's something on which there is an extraordinary level of consensus internationally, that family is one of the most important things in life. And so when it comes to making decisions about how we order our society, and when it comes to drafting our laws, be it our national constitutions or international human rights law or national legislation, that importance of family and the sensitivity of the relationship between families and the state is something which is universally acknowledged. And if you look at the constitution of most countries, you will see an acknowledgement either that there is a right to family life, or phrased slightly differently, that family is something which should be protected by law or supported by the state. So the exact wording can differ from one place to another, but the sentiment is similar, that family is very important, that family has rights, that states and governments and laws must protect family. So that is something on which there is, as I say, a huge level of international consensus. There probably are few things that so many people agree on. But once you get past that initial statement and you start to look at the detail of that, what we see is that there is almost endless room for disagreement about what that actually means in practice. So there are so many questions you could ask, and I'm going to explore 3 of them in my presentation this evening. The first of which is, what does it mean to say there is a right to family life? What does that right protect, and what is included within the scope of that right? What does it require of state authorities? What obligations attach to it? Secondly, and this follows on from much of what Marisa has discussed, what is a family? Who qualifies to seek the protection of the right to family life and to invoke it before the courts? And then thirdly, who can assert that right? Because a family, of course, is ultimately a group of people. A family may have parents and children. And when we look at the family unit, it may often be the case that the interests and rights of the people within that family unit all coincide. But it may also be the case that there are different interests and that rights can be in conflict or tension with each other. And in those cases, who gets to assert the right to family life? Is this solely a matter for parents, or what scope is there for children to independently assert the right to family life? So answers to those questions will vary from one country to another, and even within a single country they can change and vary over time. And I think it's fair to say that in many countries the right to family life probably means something very different now to what it meant 30 or 40 years ago. So what I'm going to do in this brief talk is I'm going to look at the European experience of this. I'm particularly going to focus on the European Convention on Human Rights, which is a regional human rights instrument involving now We were for a long time saying 47 countries until Russia was recently expelled from the Council of Europe, so it is now 46 countries. Within that, I'm going to look at the case law of the European Court of Human Rights interpreting Article 8 of the European Convention, which is the right to private and family life. But I'm also going to make a number of references to some national decisions, in particular to Ireland, not just because I am from Ireland, but also because we have quite an interesting case in our constitution where it includes very detailed protection both for the family and for children. So in places I will digress from the international approach. So to begin on the first question, which is the scope of the right to family life. And this is something which the European Court of Human Rights has developed very extensively over many years and over a very large number of judgments of the court. And so we see at a basic level, the right to family life is a negative right which imposes negative obligations on the state. That is, it obliges the state to leave families alone, to stay out of family life. And that means that families should be free to make certain decisions, such as how many children to have or how to raise their children, without state interference. States should not remove children from the family unless there is a very strong justification for doing so. Now, the European Court of Human Rights is very conscious that as an international court, it is often not best placed to make assessments about whether a particular removal of a child from a family was appropriate or not. And it will give countries a very wide latitude to make those decisions based on the local assessment of the facts. But it still sets red lines which should not be crossed, and in particular has developed a long line of case law about adoption of children from care, really emphasising that children should only be placed from foster care into a permanent adoption, which terminates parental authority in the most extreme cases, and this should be a very last resort. And there's been quite a number of cases where the court has found that decisions to place children for adoption from the care system violated the right to family life. But that idea of a negative obligation, it's important to say, is quite an elastic concept, and there is variation between countries as to how far that goes and how much power the state should have to intervene in family to protect children. So it's not a simple assessment that will remain the same from one place to another. Now, on the other side, the European Court of Human Rights has also developed a strong doctrine of positive obligations on the state. So it's not simply a case of the state leaving families alone and staying out of family life. States also have positive obligations to recognise and protect family life where it exists. And this ties in with some of the discussion around the changing nature of family life. So there have been numerous cases in situations where you have people who are living as a family, but where perhaps the law does not recognise the family ties or family life existing between them. And violations have been found in cases of that nature where the court has found that there is an obligation on states to put in place laws that allow people to have their family status recognised by the law. So that's one form of the positive obligations. There are also very detailed bodies of case law on the positive obligations that states have to intervene in family life to protect children in particular, but also potentially adults in situations where one member of the family perhaps is being abused or neglected at the hands of another member of the family. And there have been violations found in a range of cases where state authorities have failed to intervene to protect children from abuse or to protect children and parents from acts of domestic violence. There have been cases where it's been found that national laws don't provide a sufficient deterrent against acts of abuse or violence. And there's also been cases where this positive obligation to protect people from abuse has been used as a shield, as it were, to resist challenges taken against state actions. For example, in the area of corporal punishment. So where you have certain groups who have a strong belief in corporal punishment as a cultural or religious practice, and perhaps state authorities intervene to remove children from the home because of the level of physical abuse. And in some cases, most notably some recent cases involving Germany, parents have challenged those decisions as being a violation of their right to family life. And the court has found that the right to family life in certain cases must give way to the state's obligation to protect individual members of the family from abuse within the family. So beyond those sort of typical cases that you get, there's also other areas where the right to family life has begun to expand beyond the traditional boundaries of family law, as it were, into a range of other areas. In the area of children's rights, we see that if you look at the Convention on the Rights of the Child from 1989, the Convention provides express protection for a wide range of children's rights, which are not protected in the express language of the European Convention on Human Rights. And what has happened with increasing frequency is that the European Court of Human Rights has taken the broad right to family life and has read it as an umbrella right within which other rights can be recognised and implied into it. For example, the right to identity, which is expressly protected in Article 8 of the Convention on the Rights of the Child, or the right of children to be heard in proceedings affecting them, expressly protected in Article 12 of the Convention on the Rights of the Child. And both of those rights have been interpreted by the European Court of Human Rights as falling under the broad umbrella of the right to family life. Other areas which have been developed include the area of migration. We see an increasing body of case law on migration, the implications of the right to family life in migration decisions, such as immigration control measures, for example, where people are detained upon arrival in a country, particularly where you have children being detained, where you have family separation, or where you have lengthy periods of detention. The European Court of Human Rights always emphasises that, of course, countries have a power to control migration. Nobody has a right to enter a country, but nonetheless there are limits to what can be done to families in the exercise of migration control powers. Similarly with deportation, of course, countries have the power to deport people, but where you have a child who has largely grown up in a particular country, there are limits to the deportation power. And in family reunification is not a guaranteed right, but we have seen circumstances where countries have made it excessively difficult for somebody who was legally within a country to be reunited with family members. And again, violations of the right to family life have been found in such cases. And finally, one other emerging area is that of gender identity. Most of the case law of the Court of Human Rights has been on gender identity has focused on the right to private life rather than the right to family life, which are separate limbs of Article 8. But nonetheless, we do also see some gender identity cases with family life implications as well. For example, a case involving Finland concerning a law which required somebody to convert their marriage to a civil partnership following gender reassignment. In that case, the court found no violation. They found it was a proportionate measure. More recently, a case involving Russia in which contact with children was terminated following gender reassignment. And in that case, a violation was found. The court found that the Russian authorities had not struck a fair balance and had looked at a very narrow range of evidence and did not have sufficient evidence to support such an extreme decision to terminate all contact between a parent and their children. So we see the scope of the right is very wide. It is growing all the time, and there's no reason to suspect that this is going to slow down anytime soon. So we see that the case law of the European Court of Human Rights really is very expansive on the question of how far the right to family life goes and the obligations it imposes on the state. Similarly then, when we come to the question of the definition of a family, we see that the European Court of Human Rights has taken a very broad view of what is a family. And that is in contrast to many national regimes. So if you take Ireland, for example, where I am from, in the Irish Constitution, we have a very rigid definition of the family. The provision of the Irish Constitution on the family expressly links family to marriage. So the only family which is protected by that article of our Constitution is the marital family. Now that includes families where you have a same-sex marriage, because we had an amendment in 2015 which guarantees the right of same-sex couples to marry. But if you have a couple who are not married, be they same-sex or opposite sex, then they do not benefit from the protection of Article 41 of the Irish Constitution. And so it's a very rigid definition. That's in stark contrast to Article 8 of the European Convention on Human Rights, where the court has developed a concept known as the de facto family. So essentially, it looks at the intention of the parties, it looks to see, are they fulfilling the function of a family? And in a wide range of circumstances, involving not only where there is marriage, or even not only where there are blood ties, but perhaps cases involving mere cohabitation, cases involving cohabiting adults, involving same-sex couples, cases involving social parents, where you have somebody acting as a parent but who does not have a legal or blood tie to the child. We see the right to family life being recognised in a very wide range of cases by the European Court of Human Rights, really trying to reflect the reality on the ground rather than a narrow conception of what is a family. Having said that, there are limits. We see particularly in the area of assisted human reproduction that the court has drawn limits in that area. For example, it has held that a sperm donor does not enjoy the right to family life with respect to children born using his sperm. And then in surrogacy cases, we see that there is a line drawn between cases where you have a genetic or blood link between a parent and the child, and then surrogacy cases where there is no genetic link. The court has been willing to recognise family life between a child and intending parents in surrogacy cases where there is a blood link. But in a case involving Italy, where the parents did not have any blood link to the child, then it was found that no family life existed between those intending parents and that child, and therefore the Italian decision to refuse to recognise the surrogacy arrangement was found not to violate the right to family life. So that's all in the context of the court, but we also see, just mentioning briefly on the question of assisted human reproduction and surrogacy, we see that aside from within the European Court of Human Rights and the case law of the court, we see the right to family life also plays a broader role in debates around same-sex parenting or around surrogacy, in debates around law reform. And interestingly in that space, and I will come back to this again in a moment, we see the right to family life in some senses being used on both sides of that debate, because of course there are people who argue in favour of increased legal recognition of relationships between children and same-sex parents, or between children and social parents in surrogacy arrangements and so on. But there are also strong opponents of legal recognition, and people who want to prohibit surrogacy or limit the extent to which same-sex parents can act as legal parents of children. And in those cases, what we see is that on the one hand, you have proponents of reform arguing that the law should recognise the reality of the family life of those children. But on the other hand, you have opponents arguing that the right to family life actually implies that we should prohibit surrogacy, that surrogacy is itself a violation of the right to family life by deliberately rupturing a relationship between a surrogate mother and a child. Or they argue that children have a right to a mother and a father, and that allowing them to be deliberately brought into a same-sex household is a violation of that right to a mother and a father. So it's very different conceptions, competing conceptions of what family life is and what family life means. And when it comes to resolving that, it's difficult because when the two sides of the debate are basing their arguments on the same right, there isn't always an obvious way to decide which one of those arguments can win out. One way of doing it is to involve social science. We see increasingly that people look to empirical research on family life and family forms and outcomes for children in different families. But that can be quite a contested space in itself, where we see people on each side quoting different studies and different research to suit the arguments that they wish to make. So it's tempting for legislators and policymakers and indeed courts to look to the social science to try and find answers about what the right to family life should mean in these situations. But some caution is needed, because the social science can be weaponized in a way and used in a very selective way to argue for particular outcomes. My time is moving on, so I want to push on to the question of who gets to assert the right to family life. The obvious answer here, and the traditional answer, is that parents and adults assert the right to family life. But in more modern times, as we look increasingly at the independent rights of children, interesting questions arise about what happens in circumstances where the view that parents have of what is best for their child does not coincide either with what the child themselves wants or indeed perhaps with what is objectively in the best interest of the child. And if we go back to where I started with this traditional notion of the right to family life as a right to family autonomy, to make decisions free from state interference, that view would be very strongly the view that parents know best and parents should make that decision. But that view collides now with this newer view that children should have autonomy to make decisions for themselves, to guide their own destiny, and that the state has a role in helping children to assert that right, perhaps sometimes in a very small subset of cases, in a manner that is in conflict with their parents. Now, what's interesting here is that the right to family life can sometimes be asserted by parents in a way where they assert it as a right of the child. But in what they're really doing is they are seeking to assert adult interests disguised as the interests of the child. I'm going to mention a couple of cases just to illustrate this point. And we've had some Irish cases that have particularly struggled with this issue. One case, a case called Re J.H., which is a 1985 case, which concerned a child who was placed for adoption. There was a delay in finalising the adoption, and after a number of years, the natural parents wanted the child returned. And when they sought the return of the child, the adoptive parents said, well, no, the child should stay with us because this is what's best for the child now. The child is settled here, has never known the natural parents. And so the best thing for the child is to remain with the adoptive parents and to finalise the adoption. Ultimately, after several hearings and appeals and so on, ultimately the Irish courts decided that the child should return to the natural parents. And part of the reasoning in the decision was that the court held that the child had a right to be a member of a constitutionally protected marital family. So it was the child's right to family life. The child's right to be a member of a family with the natural parents was the right which was the basis for making that decision. Even though the evidence presented before the court was really that this risked being very damaging to the child and perhaps causing long-term harm to the child. And so there was a lot of criticism of that decision, that even though it was articulated as a children's rights decision, people criticised it by saying really it was actually a parent's right in disguise. The child's right to family life, as the court called it, was really the parent's right being asserted. Similarly, when it comes to the best interest principle, we have seen that the best interest principle in Irish law has been interpreted by the courts as being subject to a constitutional presumption that you must read the legislation in light of the Constitution, in light of the strong protection for the family. And they've said that there is a presumption that the best interests of the child are served within the family without state interference. And it is very, very difficult to rebut that presumption. So in another famous case from 2001, involving the PKU heel prick test, which is a routine test on newborn babies. A little bit of blood is drawn from the baby's foot to screen the baby for diseases. It's no risk. It's a very strong benefit to the child. And in a case where parents refused to consent to the test, and the case ended up in the Supreme Court ultimately. And even though the Supreme Court accepted that it would be in the child's best interest to have the test objectively and scientifically, that ultimately that they must presume that the parents know best, and that the best interest principle we presume that the best thing for the child is for the state not to interfere. And ultimately it was decided not to go ahead and order the test in that case. And what we saw in both of those cases was a lot of discussion around the fact that even though the courts were speaking about be it the right to family life or the best interest principle in what was on the surface a child-centered way, that actually what seemed to be dominating was the rights of the adults, the rights of the parents. And what was also quite evident in those cases was that there was nobody in court to speak for those children. There was nobody independently asserting the rights of the children. It was presumed that the parents, in asserting the rights of the children, that they knew best and that that was sufficient. And so what we see is very important in that respect, that when it comes to asserting the rights of children, that there needs to be some sort of framework to say, is it enough to simply presume that parents always know best, or is there a need, be it for mature children to ensure that they have independent representation, that they can speak to the court directly, or some other mechanism that provides independent assertion of the rights of the child before the court, so that you don't just hear one side of the story, and that you avoid the danger that adult-centered interests dominate the discussion, and act as a smokescreen to the interests of the child. So in conclusion, I think I have 1 minute left. In conclusion, I think looking at all of that, I think what you see from everything I've discussed there is that when it comes to the right to family life, as we say in English, the devil is in the detail. It is an easy statement to say that families are important and there is a right to family life and families should be protected by the law. But that really only begins the discussion. There is so much detail to be worked out below that. And this is detail on which views change from country to country and views change over time. And so the challenge for international human rights law is, how do we set, on the one hand, ambitious standards, while at the same time leaving room and flexibility for individual countries to chart their own path dependent on cultural differences from country to country. At a national level, there is a slightly different challenge, where at national level you can perhaps afford to be a little bit more specific based on a particular country's cultural conception of family. But at the same time, if you are too specific, as perhaps in Ireland at times we have been, especially at constitutional level, if you are too specific, then you can put in place constitutional principles which act as a barrier to much needed reforms. So on the one hand, the vagueness of the right to family life, to say that the right answers very few questions in itself, that vagueness can also be its strength, because it provides it with the flexibility it needs to allow for families to evolve and for the law to evolve along with them. But on the other hand, we need to be conscious also of the dangers of the vagueness, as I mentioned towards the end of my presentation, that if we have too little structure around how we decide cases on the right to family life, then it does risk, in situations where the right to family life is argued perhaps on both sides of an argument or by two different members of the same family, then we might not have the structure we need to resolve those disputes. So it is a difficult balance, but that is perhaps what makes it such an interesting area of law to work in. So I hope that's been interesting, and I'm happy to discuss further in the questions. Thank you very much.
Muchas gracias, Conor, por tu extremadamente pedagógica presentación, por la claridad y por hacernos también este recorrido por esas transformaciones que en el contexto europeo es interesante lo que dices, a diferencia probablemente lo que...
The difference between to what we're used to in the inter-American system, where the court tends to be, you know, more active and more precise in saying everything that we have to do and how we have to do it, maybe because there is a lack of trust that the states themselves could do this themselves, right? And unlike that, the European system, of course, the court has been more deferent with the way in which states have been regulating their pivotal rights and limiting them as well. But also it's interesting to see how, with important cultural differences, even if they are sharing a project, a democratic project, a common democratic project, more religious or less religious countries, more liberal countries, while others are more community inclined, so have such a broad concept, so we can have a flexibility to move around the different dimensions of the protection of that right without stepping on states, and at the same time being able to move forward in the levels of protection with the flexibility and to incorporate other rights to the different legal precedents. I'm going to make some questions, and then we have given you some paper sheets in case you want to make some questions that we will address during the second time, and I'm going to start. I would like to start with Marisa. She is, well, it's always very enlightening to listen to you. And I wanted to ask you something about tensions between principles, because you said that in order to understand a family, the right to a family, in motion, you have to consider on the one side the children's right and then the gender approach. But sometimes these principles seem to be in conflict and tensions arise. We conducted a project on, surrogatory reproduction, and we started to discuss because everybody was saying like, why are you even discussing about this? So everything started to grow difficult, and we needed to discuss about details so we could start, speaking about the protection of, women in gestation, things like that, and sometimes it's not apparent. But I'm sorry, I'm not being clear from my question. But this can be a conflict, and sometimes it seems that this concerns rather political aspects of it, But here, what's more important is the gender approach. But then we have the best interest of children. So, in your academic experience and in the processes of reform with social movements, what happens in these cases of attention? What happens with these two principles? What can you tell us about this? Well, I'm happy for that you evoked this trigger, because surrogacy is a really good figure where we have this apparent tension between the children focus and the gender focus. And I'm going to tell you why this is apparent, because when we consider gender and feminism, simple, they have an important internal conflict. As a feminist, I am in favor of, for surrogacy, and I am feminist because this also concerns the autonomy of bodies and the decision upon them. In Argentina, 66% of legal presence are because between family members, sisters-in-law, and the question here is, if they want to be pregnant to help their sister-in-law, why should we forbid this to them? And here you could say it's exploitation, but when because people are usually against because they think about exploitation. It's not always that. Are there cases of exploitation? Yes, but it's not all black and white. So we have to regulate in order to control. Of course, we have to regulate to control. And not all of the cases are of exploitation. So now we have the children's, children focus. Now, if we allow for a surrogacy, this is a source of creating, family links, so for more children to be born. So this is not a versus. So this is an and in this case the question would be, what would be the level of protection, or how the figure of gestation should be regulated for there to be a compatibility between both focuses, instead of just going for the exploitation of women, which is what has been discussed. And I think that that's a clear example that one believes that there is some kind of shock, but there is no shock at all, because we know, depending on how this is going to be regulated, then we can have some compatibility. So that's why we need to have this balance, and it's here what we have the main challenge. How can we think about regulations stemming from the idea that we can have a balance and an imbalance? And another topic, in Argentina we have been moving, we've been making a lot of progress. Maintenance has always been considered from the children focus. So if you do not comply with this is a violation to children's rights. However, this is not a versus. Also, this economic violence to women, because those who end up having to, taking care of food, and fighting injustice so they can, get that, resources. It's them who have to, stop, and they have to solve this, and they have to conduct a double effort. It's not either children's rights or women's rights. Children's and women's rights come to strengthen and robust this right to, to support. So the right to, in this not versus, but rather and the gender and children focus will allow us to have a broader outlook and a deeper outlook in terms of rights, and so we can answer to this, balance, that, and instead of believing that there is some, apparent shock. For us, this process was really interesting, having, working with jurisdictions, and because, well, we have this to, this is a dilemma we have. It's not some are in favor of children and others that are in favor of, of gender. So we have to achieve, the balance between both. And I'm going to tell you something else. We were speaking about specific suppositions of link between mothers and children. Mothers in a prison, it's not a gender focus or children focus. For both, it's really good to think again about inside, outside, in a situation where we have mothers in prison in favor of gender and in favor of children. And in favor of gender, it means that women who are in prison must not be demonized, must not be considered as bad mothers because they are in prison, because they don't, the fact that they're in prison does not mean that they are bad. Sometimes it's because, these concern crimes that are completely, different from their link to their children, right? So we have here a collision, but not everything, is a fight here. Thank you very much, Marisa. Conor, you were speaking about, at the end of your presentation, for these three components of the right to family life. That third dimension of, who in the end is going to assert the right, is going to demand for there to be a family topic. And we have the conflict as well, and the tension between parental rights on the one hand and the children's and adolescents' rights on the other. And the cases that get to the European Court or to many of our courts are precisely cases of two subjects of rights that have a good reasons, a father who thinks that he must, interfere, in, reproductive matters, and a girl and an adolescent who is like, no, I have a competence to make my own decisions in this regard. For instance, in terms of informed medical consent, for instance. And the question I want to make you is, well, I believe, and some years ago, at least in the European context, there were some kind of clarity that the best interest of the child may be the most relevant interest, and that the other ones were important, but they were under the superiority of the best interest of the child. In English, sometimes we use paramountcy, sometimes we use other phrases that describe, that make the difference between the best interest from another one. But I see a tendency here to decrease, the protection of the best interest of the child. It becomes an important interest, with a relatively specific weight, but that may be just, a greater. But we see a trend, to have more weight for parental rights. So at court we have, a balance, between all the types of rights, So this is related to my previous question, and I wanted to ask you whether you saw that the superiority of the best interest of the children has been decreased in the European context in the debate of judicial interpretation. Or maybe it has been decreased in terms of its intensity and has become more parallel to other relevant interests. But is it still the triumph card, so to speak, in general terms? At the end of the day, there is, the paramount, the superiority of these principles above the principles of another subject, even if that is also a subject of rights. I'm sorry that I, make such a long question, but I was trying to explain the problem here.
Thank you.
Muy bien, gracias.
I'll try to be as brief as I can. It is a pretty big question because when it comes, the best interest principle, a little bit like what I was saying about the right to family life, to say that the best interest of children is the primary or paramount factor in a case involving children is, again, deceptively simple. It sounds very simple, that the children's interest must always come first. But first of all, that ignores the whole question of what is in the best interest of a child in a particular case. I mean, in many of these cases, the reason that the case is in court to begin with is because there are different views on what is in the best interest of the child. And so a court has to make a decision on that, but the court is going to hear evidence that there are perhaps two parents who have conflicting views on what is in the best interest of the child, or perhaps you have parents who have a different view to medical professionals or social workers or some state representative who has a different view on what is in the best interest of the child. And in a small number of those cases, it may be reasonably straightforward, so if you have, for example, a case involving a Jehovah's Witness child who needs a blood transfusion or else they're going to die, and the parents have a religious objection to that, well, those cases are reasonably straightforward. The courts will say, give the child the blood. But the big cases, the cases that really matter and the cases that we all talk about and write about are always the ones where it's more complicated than that. And the literature on the best interest principle, I guess, over the years has always been to the effect that the great weakness of the best interest principle is that it is so subjective. And it doesn't, it provides an awful lot of room for judges and lawyers to just insert their own meanings into that broad phrase. But then the other thing I want to say is going back to the point I was making about the Irish case law, the Irish case law that has said that the best interest principle is subject to the presumption that parents know what is in their child's best interest. That principle is not a uniquely Irish thing or a problem in itself. I mean, the UN Convention on the Rights of the Child would say that normally the best place for children is with their own family, and recognises that in various points in it. So the issue is not the principle. The issue is, what does it take before you rebut that presumption? So how serious does the case have to be? So I mentioned the heel prick case earlier on. I mean, in that case, it was pretty clear that what the parents had decided was not in the best interest of their child. But essentially what the court said was, yeah, but look, the damage won't be that bad. So this is not a good decision for your child, but actually the damage isn't so bad. So that's not enough for us to rebut that presumption. So that then it raises the question, what is enough? How serious does a parental decision have to be? How much does it have to damage a child's best interest before a court will say, now we will authorise intervention? And again, that's something in which there will be different views. The criticism in Ireland essentially has been that they've made it too hard to rebut that presumption that parents have to do something incredibly damaging to their child before you will decide to rebut it. So to what extent is it weakening? I mean, I'm not sure I would use the word weakening, because that maybe suggests that there was a time where the best interest principle was clear cut. And I'm not sure there ever was a time where it was simply a clear-cut case that the interest of children should always prevail. It's always been a more complicated situation than that, and there's always been a degree of controversy around what exactly does best interest mean, and whether or not courts should be the ones to decide that.
Muchas gracias por esa respuesta, Conor. Tenemos
Conor,
para un par más de preguntas.
We have time for a couple of questions. This is a question for Marisa. This is a question coming from the audience. I'm going to rephrase it, but basically it is asking how, from this perspective of the higher protection of the children and this phenomena of the application and what is called parental alienation. Here they don't mention the word syndrome, so we can skip that debate. However, there is a lot of countries that prevent to use the word syndrome, but it would be good to hear Argentina's experience on how parental alienation is observed, and in your opinion, if that approach is correct or not. What are your reflections about that? Well, first, in Argentina, this parental alienation syndrome, it has been a really strong idea for several sexual abuse cases. So it's been really difficult for us. This thing about I believe the child, and what if we should believe what the kids say, and also how they behave, their attitude, and all of that. When it comes to sexual abuse, we should focus on all of those things. So it's been a debate that was like generated in this framework of whether to believe the children or not. So it was a big issue. So that's why this parental alienation syndrome has been quite rejected by the majority of Argentina, and it's still present. It's still a minority of people that consider it as a syndrome. And I also like to talk about the parental conflicts, like strong and complex conflicts. And in that context, we should see this context of debate between adults that needs to be taken into account, because I always say that when Argentina was going into these different divorce reforms and changes in that area, if I have divorce and I say that he was unfaithful, and I hired like a private investigator, and I have photographs and witnesses, it is difficult. I mean, if he brings me the child like 10 minutes after what he said, that he's not valuing my time, I mean, there's a conflict that will be, maybe he's a good parent and he was a good bad husband, and sometimes that affects the way that men are perceived in cases like that, and we have to take that into consideration. But parental conflicts, and the great question here is this like an overview that should incorporate or consider the intervention of these conflicts for the higher interest of the child. And I think that the most essential thing here is this figure of the lawyer of the child, because the parents want the higher interest of the child, because they want their own interest, and it's difficult to differentiate what they want and what their kids want. The interest of the child is what they think it's best. So this idea of parental conflicts and thinking about a different figure that will actually be able to work from the child's perspective with the child, I think that's a good figure for this type of conflicts. And in Argentina, that figure of the legal representative of the child has been used in these parental conflict cases. So I think that's the key. And also, this is not about just alienation, because it sounds almost like a genetic disease. Let's talk about social construction and not nature. So we should step out of these concepts that haven't helped and that have damaged everyone in jurisprudence in general. So let's just look at parental conflicts. If there's a conflict, divorce or something, this will harm the situation, and we should find a way to think about the interest of the child and how the lawyer can play an important role there. Thank you, Marisa. This is an endless debate, and we are always discussing about it in different forums. So I like that idea of resignifying it as something conflictive, because the phenomena, it occurs, it happens. You cannot unsee that. It's just about how the concepts are used. If maybe there's a better way to understand the full picture. And this dispute has been here for a while, so let's propose something different. These parental conflicts, let's talk about the different context. Is it the same thing to have a parental conflict with a 2-year-old or maybe with an adolescent? It's a different way to handle it. And if this kid doesn't see his or her father, and this is a teenager, and they just don't want to see the father, we should just let it go. We should let it go, this therapy and forcing them to connect with their parents. If you didn't make this kid to actually want to see the father, then there's no way for justice to fix what reality has broken. We have to learn to let go. We should find ways to identify when we have to let go. And it also implies that we are flexible, we're humans. Also judges are human, and we should be able to determine that maybe it's gone too far and that it's going to be even more difficult if we continue. Thank you, Marisa. We have enough time for one question for Conor. I want to make this question about the expansive character of family law in the European context, because you were explaining about this negative vision and how you can move to a positive vision, but there are different rights that are start getting intersected in the family scope, and that the court is considering it within the Article 8. It's not just considered as an equality thing or identity thing, but it's incorporated in the construction, in the dogma of family life. And do you see, I mean, if you project that expansion, then up to what point can you expand the content or the scope of family life? Maybe it could harm the clarity, the legal clarity that exists in the content of law. Do you see any harm in this extension? Should it be controlled somehow, given the way it is understood, how family life is understood? What do you think about this expansion and looking into the future? What's your projection for the future?
Yes, it's a good point, and it's a point you hear mentioned about other areas of the law. I mean, for example, I've done some work in the area of dignity in constitutional law, and one of the big criticisms of dignity as a constitutional principle is that dignity can now mean almost anything, and that as a result it therefore means nothing. And so you could look at the right to family life and say, is there a risk here that if we continue to expand it, that it could run into the same difficulty, that if family can mean anything, it means nothing? And I think that's a valid point and a valid concern. At the same time, I think when we look at where we've gone so far with it, the expansions which have happened in the right to family life have all happened for reasons. You know, they have happened because families have changed, and the law needed to reflect that reality. You know, in a sense, the case law has followed the reality on the ground. You know, the European Court of Human Rights sitting in Strasbourg has not been trying to shape families. It has been responding to what it sees happening. And so that is important. And to the extent that it has used it as an umbrella right, it has been taking its lead from the Convention on the Rights of the Child mostly. So it's been looking to other international human rights instruments. So I think it hasn't been a case of it just picking things out of the sky and going anywhere. Anytime that there has, it's been very incremental, you know, slowly, piece by piece. There's always been a good reason for the decision, and importantly, they have also set limits. So there have been cases in which they say, oh no, we will not go that far. We will go this far but no further. So as I mentioned, we've seen that in some of the assisted reproduction case law in particular. So where will it go in the future? I mean, in a sense, it's difficult to predict, because some of the things which have happened in the last 20 years probably wouldn't have been predicted 20 years before that. You know, I think if you had asked somebody in 1970 about case law on gender recognition and surrogacy, you know, that nobody could have seen that coming. And that is, to my mind, precisely why it needs to be flexible, because we don't know what the future holds. So I have no issue with continued expansion. I think continued expansion is the right thing if it is reflecting the changing times or changing values. Where the court risks running into difficulty and challenging its legitimacy is where the court begins to try to lead too much rather than to follow. And that's why you mentioned earlier on some of the tools that the court uses. For example, the margin of appreciation, where it gives states flexibility to have their own conceptions of family law. And also the way the European Court allows consensus, so it usually won't force states. If you have something on which there is no consensus, then that's where it gives the most margin of appreciation. So for example, on gender recognition, the court allowed a lot of space until at such time as it was clear that a majority of European states were moving in that direction, and then it started saying, right, to the states that were lagging behind, now you must catch up. So for the European Court of Human Rights, it follows more than it leads. And maybe that's a little weak at times, but for an international human rights court, I think it has to be conscious of the limitations of its own power. And so on, and the expansion of the right to family life, I think as long as the court is cautious and incremental, I have no problem with continued expansion. And in fact, I think, as I say, it's important to do that rather than to do the opposite, which is to have a concept of family which no longer reflects modern family life. We've had that experience in Ireland, and that creates, if anything, a bigger problem.
Muchísimas gracias, Conor. Es una tremenda pregunta, una pregunta que enfrentamos muchas veces en América Latina, en el litigio.
Litigation, and it is interesting to see like the contextual differences of both systems. It's not just the case law in the Article 8 or here or there. There's a cultural, institutional context here that make courts sensitive to that context, and it happens a lot regionally. We have to wrap up because we are broadcasting and we have to stop the event. I want to thank Marisa Herrera from Buenos Aires and Conor O'Mahony from Cork University in Ireland for joining us today. Coming to Mexico, we are still under challenging times, so thank you for coming, for your interesting remarks. And I just want to say that this conference, just as an interview that we conducted this morning, we're going to be uploading them into our platforms in Twitter, in the Constitutional Study website, and also in the International Network for Family Law. So please go to these websites, share them. This is an open space for knowledge, and we want to maximize its results. So thank you so much on behalf of the Constitutional Studies Center, and we'll see you in another conference in September. Thank you.